Tiffany Woods for the people.
All right, there she is. All right.
Good morning, Your Honor. Joe Simon on behalf of Mr. Clark. State your name, Michael.
Your Honor, my name is Michael John Clark II.
All right. He's here for purposes of arraignment on a stalking case.
Waive formal reading, Your Honor. Stand mute.
And in every way, formal reading, standing mute, the court will enter a not guilty plea on his behalf. This is mine. I will set a retrial in this case for April 6th, 2026, 9 a.m. As to
I don't know if the people want to go first.
people have a request on bond.
Judge, I'm just pulling up the case. I need one moment.
All right. I don't more on it.
Your Honor, before she speaks as to bond, this is a case that's going to be before Your Honor. Is it possible to schedule that at 10 o'clock instead of 9? I have to be in Chelsea at the same time. That would work out perfectly.
Two things benefit him. Yes, I'll set it at 1 p.m.
I should be quiet. Ms. Woods?
Yes, Judge, are you ready?
Oh yeah, I'm ready.
So, Judge, we'd asked for no contact with Peyton Lee Trelfa, and we're also asking for a GPS tether hot zone. The address would be 244 Oak Lawn Avenue in Ypsilanti. So I guess what happened here, Judge, was the defendant and victim in this matter work with one another and previously dated. The victim ended the relationship and the defendant repeatedly followed her at work. On one occasion, when she was leaving work and walking to her car, the defendant chased her in the parking lot on foot while she was attempting to go to her car. On another occasion, she was attempting to talk with the victim. Then the victim told defendant that she did not wish to talk with him. And then she also texted her supervisor telling him that the defendant would not leave her alone. And then at some other points, he would stand outside of her vehicle. He would continue to follow her. He not only with the text messages, he was sending her gifts at her home address. He also left her a beverage at her locker and work. So we're asking for no contact with the victim based on those allegations. Judge, we would also ask for all standard bond conditions, including no assaultive behavior, no stalking behavior, no firearms, ammo, components, or weapons. Do not possess or use any devices for creating gun components. No alcohol, drugs, marijuana, and not to leave the state.
What was the address you gave me that you wanted to no go?
244 Oak Lawn Avenue in Ypsilanti.
Said Oak Lawn?
That's correct, Judge. I will spell it to you. It's OAKLAWN.
And there would not be a need for the 1200 State Circle, or is there a need for a no-go to that address also?
Let me see. Is that the work address? Let me look real quick.
It's the stated address in the complaint.
Your Honor, I do have information on that one. It's my turn.
Will it clarify?
It should.
I believe the 244 Oak Lawn Avenue is the address where the victim lives.
Yes. The 1200, Mr. Simon, do you know what that is?
I do. That is in fact the work address. It's Huron Valley Ambulance. My
Grand Valley Ambulance?
yes. And, you want me to continue? I'll wait till it's.
Are they both still working there?
That's what I wanted to clarify. They are, Your Honor, but they are and they aren't. So I know you're going to roll your eyes at that statement, but my client, this matter was investigated internally there. My client is technically on administrative leave. The investigation there is concluded. The only reason he's not fully reinstated at work is because of this pending matter, and they want to see how it resolves. But here's how HVA handled the matter. My client is has to be there present 1 day a week. To his continuing education is there, but he arrives at a time that is a completely different shift, separated by like 3 hours from the shift of Ms. I don't know how to say her last name, Tralfa. She is on a night shift, gets off at 5 a.m. On Wednesdays when he goes to his continuing education at 8 a.m. That would be the only time he is on that campus is on Wednesdays at 8 a.m. And he does want to be able to continue because otherwise he will lose his employment. And so he has no problem at all with a no contact. He not only will not go to the address in Ypsilanti, but he lives in Hillsdale. They have quite a geographic distance between them.
I guess with that explanation, what happens if her shift changes?
Then he's going to have to not be around to comply with his bond conditions.
Right. Okay, I get that. But does HVA then switch his shift or what?
Well, just tell me.
We have a shift that changes every 6 months. So until for another 3 months, but we have our new one. And they've already set up my work shift being on different days.
Right. Your Honor, he's saying that the rotations in schedule don't happen for a number of months, and the first review is 3 months out.
Yes.
So the earliest there could be a change would be that.
3 months from now. All right. Okay. Anything else you want to say, Mr.?
Yes, Your Honor, I do request a personal bond. My client's a lifelong resident of the state of Michigan. He owns a home in Hillsdale. I've explained the employment situation. I did tell him there was a possibility of a GPS tether just because of the nature of the charges. I can tell Your Honor that I don't have the complaint in front of me. I don't know if it lists a date range, but I can confirm from what I understand that there is a cessation of all contact a date in February, that there hasn't been any contact. There won't be any future contact. My client will abide by any court order to refrain from contact with the complainant. And if the court imposes a tether, he's prepared to walk right over to community corrections today. I alerted him that that was always a possibility. And he's not a drug user or alcohol user, so he'll abide by those conditions as well.
Court will set the defendant's bond at $25,000 personal cognizance. I will order all standard, including no assault behavior, which I'll go through specifically. No possession of any weapons, firearms, ammunition. There is also to be no possession of any alcohol, recreational marijuana, or any illegal drug. Do you understand that, sir?
Yes, Your Honor.
Hesitated. You understand what I
I
just?
think he wanted.
I was reading what was being written down. I apologize, Your Honor.
You are not to leave the state of Michigan without permission of the court. You're not just indicated to possess a firearm, ammunition, or anything fashioned to be a weapon. You're not to assault, terrorize, frighten, intimidate, stalk, molest, harass, or stalk anyone. You are to have no contact with Peyton Lee, is it Tralfa? Except with a civil standby with the police. And when I say that, you are also not to have or attempt to have any direct or indirect contact with the above named individual in person or through others. You are not to have contact by electronic communication, but this is including but not limited to phone, email, texting, internet, social media. You are not to refer to that individual in any social media, should say, or online in any You understand that, sir?
Yes, Your Honor.
You are not to go to the 244 Oakland Avenue in Ypsilanti. I'm also going to indicate that you are not to go to the 1200 State Circle if Miss Trausa is present. That way, I think, could cover it if this extends beyond that. So if she's there, you can't be there. Understood?
Yes, Your Honor.
That's not your home address, but if it were your home address, you would need to find another residence. You are not to violate any criminal law. You're to personally appear at all court proceedings and other places as directed by the court. I will place the defendant, if I hadn't said so, on.
There it is. The judge sets a $25,000 personal recognizance bond with strict conditions and a GPS tether. That's huge. It means the court is taking the allegations seriously, but still allowing release. The tether? That's about control and accountability.
A GPS tether with the exclusion zone as requested of the Oakland Avenue in Ypsilanti. Anything further from others?
What did you want to tell
Nothing from the people.
Transfers.
them?
Like,
When you want to go out of state, you'll ask and we'll get position.
okay,
It's
just as it happens randomly. So that was my only concern. I can tell them no, I guess.
Are you traveling between now and your next retrial?
No, sir.
Okay, we'll address that then. My client was just saying that every now and then his job would require him to go out of state for transferring a patient or something. And I asked him if he had anything before the pretrial. He doesn't believe he does. And I know the court doesn't like to give blanket permission on that, but.
Right. I think if you talk to the prosecutor, maybe or work something out that would allow its travel.
Thank you, Your Honor.
All right. Thank you.
Wait for me in the conference room.
Court does call the case. People versus Dominique Bailey. Court calls the case. People versus Ahmad Issa. Why are they on this? You should only be given whatever date is.
This was a felony conviction.
I know it gave, but I don't know why it was giving two different dates.
If
We'll move that one. Ahmad Issa.
Sure.
Seriously, you are before the court on a felony complaint it's a 2-count felony complaint that alleges that on or about March 7th, 2023 at the location of 3020 Washington Avenue and also at 2190 West Michigan Avenue. Number one, that you did commit larceny in a building. Do you understand the nature of that charge, sir?
I do not.
Pardon?
I don't understand the nature.
Okay, here we go then. The complaint alleges that on March 7, 2023, at the location of 3020 Washington Avenue, and I think also then there is a transaction which occurred at 2190 West Michigan Avenue. Count one alleges that on that date that you did commit larceny in a building, specifically states that you did commit the offense of larceny in a Crunch Fitness by stealing a credit card, cash, contrary to Michigan statutes. Do you understand now what you are charged with?
Yes.
That is a felony, punishable by up to 4 years incarceration, a $5,000 fine plus court costs. Do you understand the maximum penalty?
Yes.
Count two alleges that on that same date and at that same location, that you did knowingly retain and knowingly possess or knowingly secrete or knowingly use a financial transaction device with.
And just like that, we move from a stalking case to a completely different felony, larceny and financial fraud. 2 cases, 2 defendants, but the same courtroom pressure. So let me ask you, should first-time offenders get leniency, or should the law stay equally tough across the board?
Without the consent of an Austin Bryant, the device holder, that is commonly known as stealing or retaining without consent a financial transaction device. Do you understand the nature of that charge?
Yes.
That is a felony, punishable by up to 4 years incarceration, a $5,000 fine plus court costs. Do you understand those maximum penalties?
Yes, Your Honor.
First question I have for you is, do you want to be represented by an attorney? It's the public defender case.
Yes, Your Honor. Assistant Public Defendant Nick Bukovich on behalf of Mr. Issa. At this time, Your Honor, will waive any additional formal reading of the complaint, restanding and proceeding to address bond when appropriate.
Defendant having waived further reading, standing mute to the charge, court will enter a not guilty plea. I'll set probable cause conference in this matter for April 2nd, 2026, 9 a.m. Yes, ask anything from the people regarding bond.
Judge, we'd ask for a no contact with the victim and a no go to the address. We'd ask for all standard bond conditions, including no assaultive behavior, no stalking behavior, no firearms, ammo, or components. Do not violate any criminal law, do not leave the state, no alcohol, no marijuana and drugs.
Mr. Bukovich.
I got you. At this time, Your Honor, I would be requesting a personal reconnaissance bond on my client's behalf. My client has no prior criminal history. He does work full-time doing medical sales. I would be requesting that he be able to return to Ohio. His primary residence is in Ohio. This is a slightly older offense, with alleged offense in 2023. After conversations with my client, I believe we do have some strong possible offenses to it. As indicated again, he has no prior criminal history. He is here today purposely availing himself to the court to get this matter handled. He's driven about an hour and a half from Findlay, Ohio to get here to get this warrant taken care of. So obviously he is showing that he takes this matter very seriously. And if I recall correctly from reading the bond form submitted by the prosecution, there was no objection to a conditional release without any cash components. So I believe a PR bond is appropriate.
I will set the defendant's bond at a $5,000 personal recognizance bond. I will order all standard conditions, including no assaultive behavior or possession of any weapons. You understand that, sir? You are understanding that this time you are also not to possess or consume any alcohol, recreational marijuana, or any illegal drugs. You understand that?
Your Honor.
I'm going to indicate that the defendant is not to go to 3020 Washtenaw or to the 2190 Michigan Avenue address. You understand that, sir?
Sure.
I will order that the defendant may return to Ohio to reside, but he must attend all court proceedings or places as directed by the court. You understand that?
Sure.
Right. Thank you.
Thank you.
Okay.
Can you repeat that quote there one more time, Your Honor?
Court date?
Yes.
April 2nd.
April 2nd. Thank you.
Thank you.
Thank you, Your Honor. Appreciate it.
Court calls the case People versus Diamond Buyer. Oh, there she is.